Hello, my name is Emily, and I am here today with nationally recognized authority in trust clause litigation, Dan Dalton. How are you today, Dan?
Doing great, Emily. It's a beautiful day outside. I'm looking forward to talk to you more about trust clause litigation.
Well, great. So, Dan, you recently had a big jury trial win for our clients, Bayshore Christian School, against the Florida Annual Conference. Can you tell us about that?
Sure. It was a great win. We're able to save the school and allow it to continue being on the property for hopefully another 100 years or so. Bayshore Christian School was an interesting case because it did not involve a challenge to the trust clause. It wasn't similar to other cases being litigated right now in Florida. The challenge was more on what's called a claim of prescriptive easement. What happened in Bayshore is that there was a large church that was located in South Tampa, and in 1971, a new school was incorporated. And at that point in time, the school set up its own articles of incorporation, had its own board, set up its own bylaws, did everything to do things independently and separate from the church. And they started using the church's buildings, primarily its Sunday school buildings, for its first classes. The school grew pretty quickly and started building more buildings on the church property, and then also bought property adjacent to the church property, kind of like a city block. You just kept buying parcels and houses all around it. So buildings were built, land was used, everything seemed to be going well between the church and the school. And agreements were made. One was a deed in 1986 that provided that the school could deeded 3 parcels of land to the church, 2 of which already had a building built on it, a family life center, which was a gymnasium and classrooms. And that land and a vacant piece of land was given to the church in exchange for the church allowing the use of the premises of the church property forever. And in 1991, an agreement was made that the school would pick up more of the joint expenses of the church and school. Like it's again, one piece of land, and you had like utilities, you had maintenance, you had all things that you would have for one piece of land. The school picked up a larger share or percentage share of the expenses from the church to pay for that as well, in exchange for the school using all the church property for free. Fast forward until 2017, the membership of the church dwindled and declined over time. The conference closed the church, citing exigent circumstances in 2017, and then demanded that the school leave and tried to evict, or the legal term is eject, the school from leaving. The school refused. The school tried to negotiate a resolution. The conference didn't really seem to want that resolution, and as a result, the conference and school sued the school to leave. The school counterclaimed on a theory of prescriptive easement, which is using the property over a period of time in a position that is adverse or hostile to the use of the conference. And through different proofs we've learned through discovery in the case, as well as testimony at trial, we were able to convince the jury that the school should remain on that property, and the jury agreed with us and allowed the school to remain. Case is not over by any stretch of the imagination. The conference, of course, has filed a motion for a new trial, and they will likely try to appeal the verdict. If the motion for a new trial is not granted, we'll continue to try to talk to the conference to see if they'll be interested in an amicable resolution. They haven't been yet, but maybe hearts will be softened and minds will be changed. You never really know. And hopefully the school will continue to move forward and continue to educate those bright minds in South Tampa, as it's done so for 51 years.
So, is this case different from the 70 church cases now being litigated in North Florida?
Yeah, it's very different. The case that's being litigated in North Florida, that is a case where they're challenging the trust clause itself, where a challenge is being made that it's been alleged that the UMC is a hierarchical church, and that because of a change in discipline and doctrine, that local churches want to leave. And that case, there's a motion to dismiss that's been filed and argued and is now pending before the court. That's the issue in that case. The conference filed a motion to dismiss based on a theory called ecclesiastical abstention, which is the trial courts and civil courts have to abstain from making decisions that involve doctrine and polity. We'll see what the court does with that one, but that's a very different case than the Bayshore case.
All right, well, thank you for your insight, Dan. If your church is interested in hiring our firm to help you through the disaffiliation process, please reach out to our office at 313-859-6000 or email us today. Thank you.